copy of the financial statements for 2010 from the auditor, Michael J. Cox.
So that's just for the board's review, the final financial statement.
Sinkholes. We've had many opinions regarding our sinkholes from the Grant Township Superintendent Kim, as well as the Village of Bolo Administrator Ken, and Sanitation and Sewer Keith Peterson, in the Village of Fox Lake. Did you want to say something?
I was just going to say, along with, you took a look at them as well, so we've had quite a few eyes looking at them.
Scott, you were on that walk around. Did you want to talk about
Scott
that?
was, yeah.
Well, basically, when we went out there, Village of Fox Lake, the two inspectors walked around the properties, and they had said that it's not a supply line, it's not a sewer line, and it's not a sanitary line that's causing this problem, at least in their humble opinions. They had said that this is a normal type of thing called compaction, some kind of compaction problem that happens. I'm not versed enough to tell you if he was telling the truth or not, but that's what he told us. And I okayed that. That's kind of what we're saying.
It seemed as though if we were to kind of cast a vote, it seemed like we were getting responses of compaction issues and backfill issues. I don't know that it's quite a dead issue yet. However, we have determined that we've got to address the sinkholes that we have before winter sets in. So if you want to kind of walk through the proposals and that sort of thing.
Proposals were DuBois paving, $3,973, Rabin paving, $1,950, and JJ pavement repairs, $2,250. The board chose JJ pavement repairs, because we have a contract as well. DuBois paving will be returning to repair 1286 Remington.
Which has been done.
What has been done?
Yeah.
Got done.
And then we also need to add that there's going to
Yeah.
be an
Then
additional.
we discovered that we had some additional sinkholes when Scott and I were walking the property. And I think another homeowner called in about the one that got the cold patch.
Correct.
So we asked JJ Paving to take a look at those as well and give us the pricing to address those before winter sets in.
So this will be an additional,
So that will be additional.
the $2,250.
Yes.
An additional $2,675 as well as the $2,250.
Can you explain what the 2250 represents?
We have a detailed contract, and he discusses about the undergrading and I don't know all the terms to
The
use.
settlement.
For how many sinkholes?
It was, I think it's 4. I think I've got it right here.
Harold, did you get those two
The
other
original was 1, 2, 3, 4 of varying sizes, and this is an additional 4, so this is 8.
So 2250 represents 4 sinkholes to be fixed? Not each, but for all 4?
Right.
Yeah, they're all
Right.
varying prices.
Yeah, they're all varying prices, different sizes. Okay, so do we have a motion to proceed?
Motion was required to ratify the award to JJ.
The first is
Motion to accept JJ.
I second that motion.
So let me just, for the notes here, so the first contract, that's going to be done before winter sets in? You said something next week?
I talked to him today, and he said that he would tie this in. I'm going to get this to him tomorrow now as well,
Okay.
and that he is scheduled to do them next week. Obviously, always weather permitting, to which my reaction was, we really need these done. We don't want to go for the
All 8
winter.
of them?
Yes.
All 8.
That's a
Yes.
CMI donation.
Yes, and he said that he would post a notice on garage doors if any of the homeowners here are ones who have the sinkholes. They'll post a notice 48 hours before they do the work, because in some cases, the sinkhole is off to an edge, and you'll probably be fine anyway. But a couple of them, they're gonna do the whole width of the drive. So in those cases, those people are gonna wanna like get their car out of the garage, you know, like the night before, so that you don't get stranded.
Make sure you tell the village to be parking on the street as well, so you don't get tickets.
Yeah, good point. Yep.
Yeah, good point. Okay? All right.
We take care of that, Nancy?
I will.
Next was garbage cans. Subsequent to the discussions amongst the board members, the majority of us have indicated they do not intend to designate another location for the garbage cans, per the language in 6:15 of the declaration. Consequently, garbage cans will be remaining inside the unit and cannot be left outside. Motion is required to ratify the board vote not to designate another location.
First that one.
Second one.
I'll third that one.
Shouldn't you have 5 people?
So you'll note that there were 3 accepting and 1 in opposition.
Next, we're going to discuss our appointment of a new board member. At the last meeting, Ryan Cruz officially resigned from the board. Accordingly, the vacancy can be may be filled by 2/3 vote of the remaining members of the board. The member brought onto the board may serve until the next annual meeting, which is July of 2012. Motion is required to ratify Caitlin Hanna to the board of directors. And Caitlin, you want to stand up and let everybody see who you are?
Say hi.
So why not have it out there?
We have a motion for that?
So they have it in the office. So why they go on the garbage then?
Mainly you know the sense.
Okay. That's a motion to accept Caitlin as our new board member.
Okay.
Thank you.
Yes.
Thank you, that's why you know it.
Yes, that's fine. Welcome aboard.
Okay, was that unanimous then?
Yeah?
Okay.
And for those, just to, you know, she was kind of a person that had run for the board, and we felt that that was a fair way to choose, you know, who we would ask to be on the board, those that had run for the board previously in July.
Welcome.
Next is committees. We've requested for homeowner volunteers for our finance committee and rule and regulations committees.
There's your chair.
Both of those meetings will be tomorrow night, November 9th. 7 o'clock will be the rules and regulations committee. And 8 o'clock will be, 8 o'clock will be the finance committee. The landscape committee has met already. Scott, do you want to talk about that?
Sure. We met a couple weeks ago, discussed some of the ideas that the committee was putting together and discussing. I did post it. I think I sent you guys a hard copy or an email of this.
You sent an email.
Yeah, I did send an email, but I can go through it real quick.
I think I called you, I was trying to find that.
Yeah,
So
yeah.
I think I said, well, will you report on it?
Yes, I will report on it. Unless you'd like to, Harold, because you are a committee member. Would you like to report on it?
Well, the only thing that I was exploring was, well, actually, a couple of things. Because there's a piece of property that's in question.
How about our?
Can you speak up, please?
They say there's a piece of property that's in question. Nobody seems to have a claim to 100%. And I found out through County Lake College that there's grants available for homeowner associations like ours to do something with that land. Now, I visited what they call a prairie crossing, and it's a sustainable landscape. And when I asked what their association fees were, I was surprised at $75 a month. And it's probably the most beautiful landscape I've ever seen.
Is it a condo community? Or is it
It's a
single
very
family?
large community. and
Yeah,
nice
it was developed as a sustainable property
Right.
Yes.
from the get-go. And I think they they had some subsidies
Good.
in building it, and I agree with you, it is quite.
It's
well-
quite
quite well
spectacular.
done.
For anybody that wants to be educated as to what natural landscaping could be, I'd say go take a trip over and take a.
Where is it?
120, or 83 and like,
Forty-five.
Prairie, yeah, 45, 83, 45, somewhere right around there.
They
Right
shipped
corner.
kids from my high school up to work out there.
Oh,
They have their own school, they
Right.
have their own
Yeah.
charter school. I think they have almost their own train station as well.
Oh, I know what you're talking about.
Yeah, it's an interesting concept.
Is
Is that,
that?
is that Green?
Grace Lake.
Grace Lake.
Grace Lake.
Grace
They,
Lake,
the
okay.
borders all run together.
The other aspect about it, they
It's between.
pretty much use no chemicals
Right.
on their turf. You can have as much turf as you want, or you can have as little as you want. And if they do use a chemical, they only do it at such a point in time where wind, rain is not gonna affect it and people that reside there. So they're very conscious of what they use if they have to use a chemical. And again, they use very little chemicals, it's all natural. The other thing I found out is proper lawn care. And I go back to when you had the aeration done here. And I found out that's only 1/3 of the step. So there's 2 other steps that go along with the aeration. So there are aspects about our landscaping that I think we should educate ourselves on. And there's a lot of landscapers out there that are strictly grass cutters. And we might have one of those grass cutters.
I
A
think
lot
we
of
all pretty much
landscaping
agree that,
companies.
I think we all pretty much agree that we need to look at the landscaping, what we're getting out of it, what we're paying for it, you know, the condition of the turf, the condition of the trees and bushes, the weeding, all of those things, and I think we have all agreed that we're gonna go through the winter through that process to look.
Absolutely.
And look, obviously, you know,
Well,
look to the
I took a
landscape
4-hour
committee.
course there, and in 4 hours, I learned quite a bit about everything that should be included as far as complete landscaping project.
Sure.
Maybe that during the winter would be a good time to work on that specification, so that when it goes out for bid, they're bidding something comparable. Just keep in mind that the current contract would have to, you have to exercise the cancellation, the termination clause.
What is it, 90 days?
I think it's 60 days.
Okay.
I think it's 60 days. Just keep that in mind.
And it's up in April.
No, it goes all the way, the contract goes through
Just
to
automatic
November
renewal.
of 2012.
Would that also
So-
terminate the snow contract with them, or is that totally separate?
No,
If-
if
if
I
it
were,
ends with
if I were in
landscaping
your
with him.
shoes, what I would do is terminate it so that the termination would be right before landscaping season. That's what I would do. So you don't wanna try to get a snow removal contractor mid-season. You do not wanna be in that position.
Is it an automatic renewal process on the contract?
No,
Okay.
no.
Okay.
Scott, do you have anything else you want to add about the landscape?
I was just gonna bring about lawn art, but I guess we got a whole second point for that, so I'll leave it for that.
Yeah, that's actually one of my questions for the attorney.
Did you
Oh.
get committee volunteers for finance and for
There were a couple,
backup?
so I'm sure that more people will probably just show up tomorrow at our meetings.
Okay,
Hopefully they will.
okay.
There was another important item that I learned about grass cutting. Supposedly, theoretically, the grass should not be cut unless it's 3 inches in length, and it should only be cut 1/3. So there should always be 2 inches of grass per. I have areas where we are, where they actually cut it down to the dirt, where there's actually no grass. And, during the summer, during those hot weeks that we have, the grass should not have been cut at all, probably for almost a month and a half.
There's a lot of things that this landscaper should have done.
Yeah, the grass to the world without their cutting that one out.
We had
Many
about
varieties
70 or
of grass,
80% weeds.
It's actually a mixture of grass that you should have,
Right.
not just bluegrass, which is what sod is. So the sod is not meant to sustain slopes during a hot summer. It goes wrong. That's why you have a mixture.
Sure. Board couldn't agree with you more that we need a new landscaper. All right,
So
so we're gonna move on to questions for Bob. Got some questions for you.
Okay.
First question the board came up with was quorum for board meetings. That refers to quorum of board members, not homeowners, correct?
Yeah.
Do minutes need to be documented for committee meetings and posted?
No, and nor should they be.
Nor should they be.
Correct. Well, you can post them if you want, but the minutes should not be kept.
You can start.
Let me rephrase that. I don't care if you keep minutes, but they shouldn't be kept in, they're not part of the association's private records. They're not subject to owner requests for documents and things like that. But actually, yes, someone should keep notes of all for camera, we should talk about it, but not formal ones. And committee meetings, unlike board meetings, are not generally, they're not statutorily mandated open to the ownership as this meeting is. So, yeah, in any event, I hope, does that answer it?
Yeah. What is the ramification, if any, of allowing homeowners to build on common elements?
Well, there's, to the extent that sometimes there's standards in documents where it can be done with permission. There's two different types of ramifications. Number one, if you allow it and you don't do anything about it for a certain amount of time, there's a legal concept called latches that sets in, and that's a Latin term. Serve means sitting on your hands. It's like it's a form of a statute of limitation. And basically what it'll do is it'll prevent you from enforcing that against that individual person that's using it. The other aspect of it, though, is that if the board is knowingly permitting this, there's case law out there that I helped to make on the wrong side. Losing the consumption case, one of my last acts of litigation. But what it says is that the common elements are for the use of all owners, and by allowing individual owners to have exclusive rights, it's essentially a wrongful giving of property to them. So the bottom line is and there's a whole subset of that that says, well, it doesn't apply in the event that only one person, only one owner would normally access the area. But the deal is this: you have governing documents, and if you should try and enforce them if you can. And if you know a violation, you should try and address them. And if you don't like the documents that you have, then you should change them. If you have rules you don't want to enforce, get rid of them. But the problem is that individuals who live in the community are relying on the board to enforce the documents. And so you may have one person who says, hey, I want to take this part of my property, this is the property next to me, and nobody says anything. Anybody say anything? Anybody say anything? Well, in reality, there may be 15 people sitting there going, well, I'm really not happy with it, but I don't have a confrontation with this person, and that's what the board got elected to do, was to enforce the covenant. So that's, there's problems with, to get back to it, there's problems with not enforcing your covenant. So if you know about things, you should do something. And then there's always the exception to every rule, but at least then you're making a reasoned decision that you can put in minutes rather than just ignoring the situation.
Okay, going back to this latches, is forcing a declaration rule for 5-6 years.
5-6 years is too late.
Okay, so now they're trying to enforce some of these.
Well, that's a noble thought.
It wasn't it may not have been enforced 4 or 5 years ago, if that's what you're referring to, but if things have just been put up recently or done recently, that's a different case.
Well, no, that is different,
Right.
and so if you look
It's not done
if you
4 or
look
5
at your
years ago.
declaration, you'll see language about the non-waiver language. I haven't looked, but it's in every declaration. I know who did your declaration. I'm sure it's in there. That basically says the board's failure to enforce any of the covenants contained herein shall not be deemed a waiver of their right, essentially, to do so in the future. So, for instance, I have a lot of associations that, the common things are people put up decks they shouldn't have put up, people put up fences they shouldn't have put up, people have pets they shouldn't have. And what I tell boards is that, yeah, the people that have had it for 4 or 5 years, nothing you can do. That does not mean, though, that you can't announce to the world, hey, from this day forward, you know, we're not going to allow this anymore.
So basically, as the board, it's our responsibility to report a violation if and when we see one.
Yes.
And then secondly, I think it's fair to say that the board that was in place before this board was appointed and put into place in July of this year was not on this property. And they were not here, and they,
Right.
I don't know that they ever came here.
Well, part of the
Rarely.
part of the issue with, particularly with architectural violations, is that someone has to know it.
Right.
I mean, you know, people do things sometimes and no one knows. So when you talk about violations, if you tell me that you've had a violation, I mean, I had one come up recently where, you know, somebody has a non-conforming front door. So, well, how long have you known about it? Well, no one seems able to tell me, but to me, it's pretty darn obvious if you have a non-conforming front door. This is a door with, you know, the doors are supposed to be clear, and this is one that's white halfway up. I said, does the door face the street? Yeah, well, somebody must have noticed that. And so if it's been there probably more than a year, 6 months to a year, and people knew about it and didn't do anything, at some point in time, latches sets in. This is the difference between latches and statute of limitation, in that latches is determined by a judge. Statutes of limitation are put into statutes that are firm dates. So it's up to a judge to determine, but when you're just getting started with an association, I think sometimes it's best to kind of recognize, like you said, you had a non-resident board, but it might be best to sort of start a little fresh and just recognize that, okay, in a perfect world, we wouldn't have these things that are there, but if their house is, you know, if somebody painted their house, you know, paint with purple polka dots, then I guess you're gonna wanna do something, but there's just gonna be some inherent inequities where you've had a building board that was not present. And, you know, we have a lot of things that are going on with the real estate collapse, where we've had a lot of builders that just, you know, haven't been on top of their game. They've been scrambling to try and stay in business or down properties, and they haven't been paying too much attention to what's going on with the property. So, honestly, I don't even know what particulars you're talking about, but they're probably along the lines, I'm guessing, of what I just said or something similar. And each case stands on its own merit. So I can't give you a generalization and tell you, I'm not giving you the generalization, I can't, but it's not about statement. You know, if somebody, you know, put in inappropriate wiring or something, and it's been there for 10 years, I don't care if we just found out about it, we've still got a right to do something about it. If it was visible, we knew about it, we took no steps, different. So you have to kind of go through each one of them, say, what have we got here? It's also different, you know, a lot of people will say, well, the builder told me I could do this. Well, if the builder told me I could do it, the builder was the board, essentially. If they've got it in writing in particular, it's pretty much of a waiver. There's not much we can do about it. Of course, I've had a lot of people tell me the builder told me to do it, couldn't prove it, which is a little different. So that's a long-winded way of saying it depends on the circumstances.
Let's say, for example, we had an issue with, a lot of people were concerned about it, they didn't want this happening, but the board was gonna do it anyways, just to think of, does that count still? I mean, especially with something like health issues, like garbage.
Oh, I'm a lawyer, we don't talk a lot about that.
I know, but that's okay. But that's what I'm saying, it just seems like there was a big outcry for this kind of thing.
Oh, the
garbage can.
the garbage, yeah, about changing.
And again, like I said, the last thing was there for, since I've been here pretty much, you know, all of a sudden it's no good. And again, it was out, it was in the open, people saw it every day, and now all of a sudden there's a problem.
The 5 years though, Nancy,
But-
that you've been in
yeah,
place, have you gotten
yes.
a violation about the garbage
Yeah,
cans?
I've gotten a
I would say
Yes.
violation letters did get sent.
Well, I got one that
But-
says I owe $25 now, it's certified.
Well,
Come on.
if we're talking about the
Violation
garbage,
letters
you
did
know, look,
get
I've
Yeah.
got this issue at a lot of associations, and there's an existing rule, correct? A rule or in the code?
It's in the declaration.
It's in the declaration. I believe that the board has
They have
a duty to enforce that. And again, going back to it, if you have something you don't like, and you don't want, you need to change the declaration now. You got something in front of you like EPA. And governmental regulations are interesting to us, but the board is really not the party to enforce those. So for instance, if there's EPA violations, you go to the EPA. If there's a violation of the village ordinance, you go to the village. But I'm not, like, for instance, you know, this is.
It's just something.
No, it's about possible air issues and I'm sure, you know what, but I'm not qualified to interpret this, and I don't know that the board is qualified. In the end, if you're really concerned about it, then the board makes a decision, we're gonna bring in, you know, an air quality expert, or we'll bring in somebody who deals with this, but I will tell you, until such time as you're sure that these provisions in your declaration are not valid, they are valid, and they are enforceable, and I think I heard a vote tonight.
From the board.
From the board, but you know, the board runs the association, and 3 votes beats 1 vote, and your dissent was noted, as I said.
I'm just saying,
That's up
these
to
folks
them,
out
then.
here.
Yeah.
Do they count?
They absolutely count, but I want to make something real clear. This is not a republic. This is a democracy. The difference is republics, everybody votes. We all sit around the tree like in ancient Greece, and we all say we're gonna hire so-and-so to do landscaping, and that's not how things work here. This is a democracy. You elect board members to make decisions for you, and if you don't like the decisions that are being made, the answer isn't that the people in the audience vote. The answer is the people in the audience vote the board members out. But I mean, so long as the board is here, the board votes on things like that. Owners have rights to vote on certain things, but they are relatively limited in associations. Primarily electing board members and some rights of involving particular size assessments, types of assessments, things like that. But for the most part, the board makes the decisions. Owners have the right to come, watch, listen, and during the open session, they have a right to voice their concerns. The board members have a duty to act on behalf of all the owners, but in the end, yeah, majority vote rules, and it's a majority vote of the board, not the owners.
And you represent the board, not the owners, correct?
I represent the association, and it's a little bit tricky in that I represent these, our firm represents, there's a not-for-profit corporation that runs this place, and it's governed by the board, and we take our direction from the board. So I take my direction from the majority of the board. That having been said, you know, if I believe that the majority of the board is doing something quote-unquote illegal, I'm going to point it out to them, and I'm probably not going to do it. But illegal is a pretty strong term. I've had some boards that have made some fairly bad decisions that I've had to enforce. You know,
Peers.
you know, and I've had some, but I've had some boards that have, you know, made some very controversial decisions that owners weren't in favor of, that the board believed was right. And again, you know, the owner's right is to elect the board members, and if they're unhappy enough about the board, then there's petition rights and a right of removal. It's all set forth in your bylaws. And for that right route. I've been to 100 of those meetings. I'd rather not be at my 101st, but I'm sure it'll happen.
And there's also a petition to change that rule, to amend that rule about the garbage can if they don't like it.
Yes, yes, it is, and I did look, and in the end, is, you know, I know we're at 2/3 vote of all the owners, of the owners present, it'd be all the owners. But that can be done via a petition, getting the bulk of the votes, and that's binding. I mean, that's, sometimes I see things that they say has to be approved by the board and the owners, but my personal interpretation is that if the owner vote is reached, that the board members have the obligation to sign the amendments. Yeah, 3/4,
Right.
3/4 of all owners. So it's a tough road to hoe, but that's what's at.
Okay.
I have a question about when you were talking about legal versus illegal. If we meet to discuss, say, putting an agenda together,
Yes,
is that illegal?
no, that's not a meeting.
So if we
You're free
need,
to work.
It's not the legal definition of it. There's a
So-
specific definition of what constitutes.
so if we need to discuss what we're gonna have here, or,
That's fine. You can't be having votes in closed sessions. All votes have to be taken in open meetings such as this.
But for instance, on the sinkhole issue, if we have to have a discussion via email and we are saying, do we want to move forward with correcting this issue, we can vote via email, is what I'm understanding, and then have it ratified at the next board meeting, especially when it's a time-sensitive issue. Is that accurate?
That's not what the law says, and that is what all my boards do.
Oh,
What?
That's what we got from your office, I believe.
well,
Well, I'm being taken. You want the legal answer?
That's fine.
That's not what the law says. The law says that all votes must be taken in open portion of the meeting. Do we have ways to try and get around that? Yeah. Are there emergencies that have to be dealt with? That's the reality. Am I confident that if we went in front of the judge is gonna ask why somebody is wasting the court's time, or something like that? Yeah. That having been said, the law doesn't provide an exception for email votes. The way that it typically gets handled is that there's an email vote and then it needs to get ratified at the next open meeting.
Right, that's what we
And
understand.
that is how associations run. And the law in Illinois has not caught up with it.
the business of running, you know, the business that we have to do, if we only have 4 meetings a year, we could
Yes.
be kind of
the
slow when we
re-
think
the-
we're
The
done.
store door is not gonna wanna wait 3-4
Right.
months
Right.
for
Well,
approval for their store.
I mean,
door.
there's two sides to this, and I'll tell you that, I mean, the history of why this is the way it is that when, I think in the 1978, possibly 84 amendments, the kind of, the open meetings provisions were brought in, and it's sort of a shorthand version of what's in the Open Meetings Act itself. There's a misconception out there that condominiums are governed by the Open Meetings Act. That's not true. The Open Meetings Act governs municipal bodies, such as the village, such as the state.
Could you repeat that?
The Open Meetings Act does not apply to condominiums. The Open Meetings Act, if you look, is an act that governs public bodies. There is specific case law in Illinois that states that condominium and homeowner associations are not public bodies. They're private. So we're not governed
Still
by
a
that. But
form
what
of
we are
government.
governed by is the open meetings provisions found in section 1889 of the Condominium Property Act. Those provisions state that that there's only three reasons why you can have closed sessions of the board, and none of them, I assure you, deal with sinkholes or contracts, and that all portions of all votes must be held at an open portion of the meeting. Now, here's the problem. That just doesn't work. It doesn't work for the very
Makes it
reasons
okay
you
to
said,
ignore it?
because we have volunteer boards that don't come and have, you know, like municipal bodies where they go to work every day and they go to work at the municipality or this township or whatever. We have volunteer boards, and the way that they tend to communicate is by email or by telephone or whatever, or they hold informal meetings where they talk about what's going to be on the agenda, or do you really think the landscape is doing a good job? And we don't really want to have to get notice out 48 hours in advance to all the owners every single time that happens. That's the one side. The second side, though, is, and the reason section 1889 was put into the Condominium Property Act is that although the board are volunteers, the individual owners fund the association, and they have a right to know what's going on with their money. And so the intent of this is to prevent boards from just operating in the dark with no transparency whatsoever. And believe me, we had plenty of those, particularly before this was passed, that operated that way. And so the trick is to find a happy balance. But when in doubt, if you're asking me what the law is, I know what the law is, and the law says that has to be decided at a meeting. So, you know, if people want to have a meeting every week, and with notice going out 52 weeks a year, then we can all comply with that. And, you know, but that's just not,
Practically speaking,
that's not how my boards operate. I know how my boards operate.
So we can ignore the law.
We made an effort to have the law changed. It did not get changed. My partner was on a panel appointed by the governor. They came up with a complete set of changes, one of which was to fix this. And that's not what got passed. So we are stuck with what it is. Here's the thing. What do I tell people? Usually I say, look, you're probably going to be fine as long as you have the votes to ratify it. But if you approve something in email, and you get to the open portion of the meeting, and the vote flips, you got a problem. So you better be darn sure that whatever you're doing, if it's 3 votes to 2, you better make sure that the 3 people are still gonna be there come the next meeting. And I'm dealing right now with a situation where that exact thing is happening. It's not normal. I mean, look, the sinkhole's gotta have to get dealt with. I don't think anybody would be very happy if the sinkholes hadn't been dealt with. And if you had to wait to even discuss it.
we
So you had
discussed
to-
the storm door.
Well, this is why the definition of a meeting was changed in this one, I'm pretty sure, 1996. The old meeting said that a meeting was any time a quorum of the board got together. So that was eliminated to state that now it's any time a majority of the board gets together to conduct board business. It used to say discuss board business. So the only logical interpretation of that in my mind is if you took out the word discuss and replaced it with conduct, then conduct must mean what you're voting. Because otherwise, there's no reason for the change. And in fact, that was the reason for the change, was so that our boards could meet informally, come up with agendas, discuss the 3 people that we're gonna bid on, review the bids, and not waste everybody's time and sit here and do it in front of them. And then when you get to the meeting, vote. People hear the vote, they know how much the dollar amount is, and they have a right under Section 19 of the Town Meeting Act, if they want to get copies of the contracts that are entered into that are current, to get copies of the minutes and things like that. So these things are covered, it's just we have a glitch in terms of how, where the vote is supposed to occur.
Maybe you can work on that one more time.
I am never spending any more. I have spent my last time with the legislature. It is time for the younger people in our trade group.
Mike,
You
Mike.
do that, I'm sorry.
Yeah, that's something very interesting.
We're gonna allow you to do this, but it's not generally.
Well, it's in regard to the sinkholes.
Yes, the
Well, we're
sinkholes.
not there yet. It's
We're
one of
coming
the
to
questions.
sinkholes.
But
We're getting there.
it
I
goes
know,
along with what
but
he's saying.
he's not technically supposed to be answering homeowners'
Oh.
questions. He's supposed to be answering
No, it's
the
illegal.
board, that's
It's
why,
illegal.
Yeah, I
right,
know.
that's why I wrote the list, and I'm right here, my next question, so let's see if I
We'll
cover
get to the sinkhole. I've
We'll
got
see if I
something to say
cover it.
about the sinkholes.
Regarding our driveways,
Yes.
there's speculation that the sinkholes are caused by sewer system, water system. What's our recourse, if any, as to who is responsible for this,
Well, if they're your driveways, the developer built them, right?
right? Is there a time frame that
Yeah, you haven't passed it.
we haven't passed it?
Usually, it's, Mike, do you happen to know the answer to this? Or shall I proceed? Mike's moving over to our department from litigation, so, but it's usually, we have a minimum of 5 years from the recording of the declaration, which I think we may have just passed